We hope you enjoy this episode of the Modern Divorce Podcast. But first, an important message for our listeners.
One consistent theme you'll hear from me, Billie Tarascio, is that we do not believe in a one-size-fits-all solution. That's why at Modern Law, you can find anything you need for your family law case. For the highest stakes litigation cases, we've got experienced family law attorneys who can offer you representation. We also have embraced newly licensed legal paraprofessionals who can offer you legal representation for less. And if you just need your documents prepared, we can offer certified legal document preparers as well. If that's not for you and instead you are representing yourself, congratulations. You are like one of the 70% of people out there doing it on your own. And our newest offering, Win Without Law School, can help. For more information about Win Without Law School, go to winwithoutlawschool.com. To get representation options, go to mymodernlaw.com.
Hello, and welcome to another edition of the Modern Divorce Podcast. I am your host, Billie Tarascio, joined by a good friend of mine here, local to the community, Ryan McPhie, and we are going to do a special episode on the Gilbert Goons. Ryan, welcome to the show.
Thank you. Thanks for having me.
I'm so happy that you're here. So first, before we get into all the goons, talk about what it is that you do.
So we are a criminal defense firm. That's all we do. 100%. We say dedicated criminal defense, both in the sense that we're dedicated to it and that is our dedicated practice. We don't do anything else.
Well, that's fantastic because I have found myself very involved in this case and kind of outside my area of expertise, learning a lot about criminal law. And I've got questions, and I'm sure people do as well. So I can't wait to get your take on the situation that's happening. Now, you are from Gilbert and live in the East Valley as well, right?
Yeah, I live in Mesa. So I've lived kind of back and forth between Gilbert and Mesa for 20 years.
I love it. I love it. Okay. So before we go into straight goons, I want to ask you about a recent sentencing of a young adult named Adam Zodrov. Are you familiar with Adam's case?
Just very little, as far as actually some stuff that I've seen you talk about, as far as his sentence, I believe, was 6 months in jail. Some people have some issues with that, and I assume that's kind of what we're going to talk about a little bit. But I don't really know the circumstances of the assault, other than it was an assault and that there was serious physical injury. I don't know if it was in the juvenile system or if it was he was tried as an adult. So feel free to fill me in as much as you can, and I'll do my best.
All right. So the situation is that Adam Zodrov, an 18-year-old, randomly attacked a 15-year-old Kevin Durkin at an In-N-Out in the middle of the day in, I believe it was August at Desert Ridge. So this is not Gilbert related, and Gilbert really wants us to tell you that this didn't happen in Gilbert. But he attacked him with brass knuckles, and this 15-year-old Kevin Durkin lost 7 teeth. He's already had to have 1 surgery. It was pretty significant. So he was charged with assault with a deadly weapon, and he ended up being sentenced in the adult court by Judge Kramer for 6 months. Now, people are fairly outraged. They feel like that doesn't seem fair. It doesn't seem right. It's white privilege. Tell us, is this normal? Like, is this what you would expect, or what could have happened?
Yeah, I mean, you got to know some more of the facts. You know, one of the things we don't know is, and maybe you do know this, the terms of the plea agreement, right? Sometimes the terms of the plea agreement are 6 months jail. We've agreed to 6 months jail, and judge has no discretion on it. Mm-hmm. Sometimes the plea is no agreements, meaning the judge can either give him probation with jail or prison. Mm-hmm. So that would be a big question to answer. What did the plea agreement look like? What was open to the judge? Now, I will say that, you know, there's a whole lot of calculus that goes into a fair plea agreement. I'm a former deputy county attorney there at Maricopa County Attorney's Office. So I was trained in that, and obviously I deal with it every day. Generally, when you see somebody charged with a dangerous offense, meaning they used a deadly weapon or dangerous instrument, it's a tougher case for the defense to go to trial on, because if they lose, it's years in prison. It's mandatory prison. Where usually the negotiation process goes, hey, if they have no prior felony convictions, that's a big kind of part of the calculation. Many times the county attorney is willing to dismiss that allegation of dangerousness in the plea agreement, meaning it gives the judge the opportunity to give probation, or it gives the prosecutor the ability to say, I will give probation, but it's got to be at least 6 months jail, or we agree to 6 months jail type of thing. And on a first offense, I know it sounds terrible, but on a first offense like this, I would not find that to be particularly unusual. In fact, jail time, significant jail time, like 6 months, is pretty unusual on a, I wouldn't say unusual, but it is a hard punishment on a first offense. So, that's one thing that people have to keep in mind, right? The way the criminal justice system is set up is to say, look, there's a balance between, punishment and trying to help people, rehabilitate, right? And we say, look, if you're on a first offense, we're going to throw somebody in prison for 5 years. What are the chances they're going to come out and be a productive member of society?
Right.
Pretty low, right? But if we say, look, we'll let you go on probation for 5 years, but you got to serve 6 months first, that's a pretty big penalty to say, okay, I better turn my life around. And if they're not able to, they're on probation. And if they get a new offense while on probation and having a prior felony conviction, now they're in prison for a very long time. So if he were to commit that offense while on probation, in this case, and I assume he's got a long term of probation followed, following the jail, then the math gets very different as far as what they would be exposed to. So this exact same offense, you would expect 3, 5, 7 years in prison if he's on probation for the same thing.
Okay. All right. The next thing I want to talk about is questions that I'm getting a lot about that have to do with the parents of the teens involved in the alleged crime. So just to give background for people who may not know what's going on, there was a terrible, terrible incident that happened at a Halloween party where a 16-year-old boy was beaten by a mob of other teenagers so badly that he died. And months later, it came out that this wasn't an isolated incident. The community didn't know about it, but there had been many kind of blitz-style random attacks by a group of teens called the Gilbert Goons. And so since that came out, the community has been going crazy. There have been no arrests made in connection with the death of Preston Lord. Everyone kind of knows who did it, and the evidence has been shared online. People have been identified. Parents have been identified. No arrests yet. Queen Creek Police Department submitted for charges to the Maricopa County Attorney's Office for 7 different people. Let's just stop there. Is that a normal train of events after a crime?
Yes. I mean, basically you have investigation that happens by the police. It gets submitted to the county attorney's office for major cases that are not misdemeanors. Those can be directly filed by the officers. Anything that's a felony or a serious offense gets submitted to the county attorney's office, especially Maricopa County. They have their attorneys review it, decide whether they think they need more evidence before it's charged. Sometimes they'll kick it back to the police and say, look, we're missing a few things. So sometimes that can take a while. Or they have their own investigators at Maricopa County Attorney's Office or the AG's office, the Attorney General. And they can do follow-up investigation, and then they make a determination, because once you charge a case, timelines start, right? So that's why, really a prudent prosecutor makes sure that the evidence is lined up before that charging hits. And many times there's so much going on behind the scenes that you just don't know. So grand juries in Arizona are mandatorily secret. In fact, if a prosecutor tells you that it's going to grand jury tomorrow, they can be charged with a felony. So it's very secret. It could be that there's a grand jury today on that case and we wouldn't know it. Could be it was yesterday and we don't know it. So those type of things do happen kind of in the process. Nothing you said about that process surprises me. There's many times that we wonder, even on the defense side, we get involved in these cases early many times. when somebody says, look, the police are talking to me, and so we know there's an investigation. We're in touch with the county attorney's office, with the detectives, and it takes a long time, even though it appears that they would really have everything to make a decision either way, that we're charging the case or we're not charging the case. And a lot of times we're disappointed by kind of the lack of finality on both sides as far as what's happening with an investigation, because, I understand they want to keep it, they don't want to taint the investigation either, but that is not unusual, anything that you told me.
How long, in your experience, does it generally take after charges are submitted for the prosecutor or the Maricopa County Attorney's Office to make a decision?
Okay, big issue right now, especially the past year. Maricopa County's Attorney's Office, I feel like they're turning it around and they're better now since Rachel Mitchell has taken over. We get aggravated DUI submittals 2 years after. It's bananas. We're seeing stuff that takes a long time. So the way the process works, and it could be that it's been updated and they still use the same terminology, but when I was there, when it gets submitted, they call them basket cases.
Right.
Why is that? Because it's literally in a folder in a basket, waiting for a prosecutor to review it for charges. So depends on how full that basket, how high that stack is how long it takes to submit. They have 7 years on most felonies to do that. Now, with that being said, they have to be reasonable, right? If they have no reason to say it took me 4 years to charge this case, we can challenge that, and say that it's unreasonable delay. Everybody has a right to some type of reasonable finality, defendants, victims, everybody. So
Rachel Mitchell just gave a press release today where she went over this basket case, and she used that term.
Oh, really?
She did not explain why that it came from a basket. So I'm glad that you said that. So she said that she has 2 experienced homicide prosecutors working on it and looking at the evidence. So
yeah,
let's assume they're looking at it. And she's also said that the police report itself is 1,800 pages. There are 600 videos. There's lots and lots of evidence. With all that being said, what might be a reasonable time frame?
3 to 6 months. If it didn't have public pressure, maybe a year or 2.
Got it.
But I think that it's getting probably, and it sounds like to me, it's getting kind of special movement from the bottom of the basket to the top of the basket, which is going to make some difference, right? So I think that just based on what we know, as far as they've given a press conference on it, that type of thing, I would anticipate it within a month to 3 months.
Got it.
But again, I tell people, again, from the other side as the defendant, you can imagine how people feel when they're accused of something. And they're like, Ryan, when can I expect a decision?
Right.
And the answer is when they get to it, right? It's as long as a string, I guess we say, right? It just depends on the process and how backed up they are. And we do our best. Maybe we're not as effective and we should use more media to to get it jumped to the front, but we don't always want them looking at our cases.
No, I bet you don't. Okay, so Queen Creek Police Department brought in the FBI to assist them with the Preston Lord murder investigation. What relationship does the FBI have now to all these other agencies?
Very interesting. We're going to speculate. Right. It could be that it's because it's a gang, right? That they are trying to, I don't know if they're trying to get it officially listed as a gang. It could be that, right? Is that there's gangs that are recognized by the government as gangs, which makes it a lot easier for them when they want to do a gang allegation in a case. And we can talk about that, what that means, why they would want to do a gang allegation. But and maybe it would go to this other case that we were talking about on why it was too lenient, and maybe that won't happen if there's a gang allegation on it. So that could be it. It could be that there's otherwise. I would, they have expertise on gangs, but so do local police. I mean, Mesa has a really robust gangs unit. Gilbert, I don't know how much of a gangs unit they have, but the FBI does. Generally, FBI is going to come in if there's a federal issue, which I don't see in this case, as far as like going across state lines or going onto Indian reservations, which, we deal with quite often, but I haven't heard any connection to any type of reservations in this case. So I really don't know why they would bring on the FBI other than to help with gang expertise.
Okay, so it's interesting you say that. Gilbert Police Department put out a statement 2 days ago saying, as part of the process, Gilbert's Street Crimes Unit is working with the Arizona Gang and Immigration Intelligence Team Force Mission, Mesa Police Department Gang Unit, Queen Creek Police Department, Chandler Police Department, Pinal Police Department to thoroughly investigate any individuals self-proclaiming or being affiliated by others with the term Gilbert Goons. They don't even mention the FBI.
Right. And so that gang unit that you talked about, that's really kind of specific to Arizona, they're very good. I mean, that is a great resource for them as far as being able to, because again, I would anticipate, and I lived in Gilbert for a long time. It was kind of the joke there that the police were bored, they arrest you for anything because there's nothing going on. It's a very safe, community to be in, which is, I think, maybe why it's so shocking to partially as far as what's going on. But yeah, I mean, I would assume they would really benefit from some assistance. Now, that being said, they're not a small police department either. I mean, Gilbert certainly has their department is competent, has resources, but just not the size of Mesa or Phoenix or these kind of statewide agencies.
Okay, well, let me talk to you about that, because there is a lot of anger and a lot of questions because there were so many cases of assaults that were closed. Why? And now they're reopened, and there's no explanation for why they were closed in the first place.
Yeah, and that's the tough part, right? Is investigations happen where they're generally not going to just close them. I mean, especially Gilbert, they're very aggressive, as I said, in their prosecution. When something happens, they are aggressive in their prosecution. Again, we talk about because we think that they're bored there, and they're really charging very small crimes many times. So if you had an assault that happens in Gilbert and it got dismissed, it's telling me, again, speculation, that the evidence wasn't there. So either, they went to trial and the victim didn't show, which can happen in gang situations, very scary for witnesses to show up and try a case. You have, or any type of intimidation that could be happening, which I wouldn't doubt. So that could have happened. I would have to know more, but generally it's going to be an evidentiary thing, because and the Gilbert prosecutors that they have there are generally actually former Maricopa County prosecutors. They're almost all former DC deputy county attorneys there that have then moved to Gilbert. So they know what they're doing. They're competent prosecutors. It's just sometimes you can't prove a case. And so, that could have happened. And then what happens is if more evidence, so if it gets dismissed at trial before a jury is seated or before, a judge takes it, potentially they could recharge the case if the statute of limitations doesn't pass. Misdemeanors, it's a year. So if they get more evidence that says, oh, wow, now we have more information tying this to something bigger, now we could charge this maybe even in a different jurisdiction in Maricopa County, Superior Court or something like that. And they can reopen the case because, like I said, even though they can close a case and say, okay, we've made a decision on whether or not to charge this case, if more evidence comes forward, they can always charge it again, unless it's barred for some reason by statute of limitations, or it went and got in front of a jury and there's double jeopardy issues.
Sure. It's frustrating not to know why the cases were closed. And there's a lot of rumors and allegations that there was foul play, there was people paying people off, and it would just be really great if the police were able to tell the community, no, that didn't happen. Here's why we closed it. But so far, we haven't gotten that. We do know.
Well, I was just going to say, I mean, sometimes, again, I see it from the other side, a lot of times where we're hoping a case gets dismissed because there's no evidence, or, I've got clients who maybe their family has a lot of money and, they're like, hey, who can we pay extra fines to so that this thing goes away? Not an option, right? Not something that I've ever seen in Arizona as far as a jurisdiction or a prosecutor being willing to bend the rules or give somebody special favors for extra money or or whatever. I've heard about it in other states. I've heard about it. I've just never seen it as far as our prosecuting agencies or courts or police agencies or anything like that. Now, is it possible that, the investigating detective is brother-in-law with somebody and they don't submit it? I suppose so, but in my experience, I just would have to see some pretty strong evidence and I'm a skeptic, and I'm not a big fan of police agencies, in a lot of ways. And so it's not like I'm here to cover for them or anything like that, but it's just, I think that narrative is kind of a natural thing for us to jump to, again, on both sides, right? You have people who are prosecuted saying, why am I being persecuted for this when the evidence is weak? And so it's just not something I've seen. It's not something I would jump to without real strong evidence.
I feel like that what you're saying is going to be very comforting to people. It really is to know that I know you and I know that you're not making stuff up to cover for anybody. I know that that's not the case. So when you say Gilbert really is safe, that's really going to bring comfort to people. And when you say you haven't even heard rumors of corruption within a police department, that's also going to bring comfort to people. So I appreciate you saying that.
Yeah. And just to caveat that, I'm not saying police agencies are perfect and that they don't have mistakes. I mean, if you look at Mesa's history, for instance, as far as, violence against suspects that was not justified, investigations that were done badly or kind of trying to prosecute people that maybe they didn't have the evidence for. So it's really kind of the other side of it, right? Kind of like overzealous prosecution versus, letting people off with connections. But
right. Okay, so I want to talk about accessories, all of the kind of, what's the right word? Communal liability that can come when groups happen to be engaged in activities. So I think people are worried, if I took a video of a fight where somebody ended up dying, what does that do for my culpability?
Yeah, there's so much to talk about here. So again, what we do a lot is we have people who come to us that say, look, police want to talk to me. Should I go talk to them? Or they went and talked to police, later on got charged and said, I had no idea I was being investigated. I thought I was helping, right? And so there certainly are some pitfalls to be had there. I think first and foremost, if police reach out to you or you have evidence of a crime that you're considering providing to the police, retain an attorney. Do it through them. You don't do it directly. And it's not because I'm trying to get people hired, lawyers hired, because even if I was in that situation, I would hire a third party to do it, because it's kind of like they say on TV, anything you do, anything you say can and will be used against you. Okay. Anything that your lawyer does for you can't be used. It's not in the police report. It's not anything that can be brought up later on. So if they do try to prosecute you, you've created a buffer for that type of evidence. Now, a lot of people say, look, I know I'm not guilty of anything. I didn't do anything. Okay, well, then use a lawyer, especially in that kind of case. Okay,
right.
But aside from that, let's start with kind of accomplice liability. So accessory, we call it accomplice liability in Arizona. You really have to have assisted or helped the crime in some way. So videoing a crime, while a lot of people might look at that video and say, why didn't you help? You really shouldn't have videoed that. You really should have helped. Okay. There is no duty to assist somebody who's a victim of a crime. It's sometimes hard to hear that. Okay. But you actually have no duty to do that as a citizen. So if you are videoing a crime happening right in front of you, there is no accomplice liability on you. Now, if you're encouraging it, you got to be careful. You better listen to the sound on that video. If you're encouraging it, if you're involved, if you're helping in any way, even just, again, go get him, right? Maybe that's accomplice. I don't know. It's skirting the line. So,
okay.
So be careful. And that's why you'd want really a very experienced attorney to review anything before it gets disclosed to police. And I know you and I have talked about this as well. Sometimes it's hard to hear that, parents are not having their kids disclose things or whatever. And any parent in that situation, our job is to protect our kids, and it doesn't mean we're saying that they don't have any consequences. There's a right way to do it. Okay, which again, you want to talk to an attorney. So I think that that's kind of the first thing. Interesting piece of the law in Arizona is if you are found to be a accomplice in a case, no matter how minor your role, you can be considered guilty of the same offense.
Wow.
So if you watch somebody commit a murder and you helped them, in some way, or encouraged them in some way to do it, even if it's the evidence you provided to the police, they can charge you with murder.
That's not good. That's not good. That's not good. That's not going to promote witnesses and people with knowledge to come forward and say, here's what happened. Especially when those people that you're talking about, they're kids. They're kids making terrible decisions with terrible consequences. But is that, that girlfriend that was yelling, get him, is she a murderer? No. Is she an idiot? Yeah. It's just hard.
Yeah, very, very difficult questions in this world. And does it mean that a prosecutor wouldn't give her a better outcome than the guy who pulled the trigger or did the actual murder? No, I generally you're going to get a better outcome even as a plea or at trial, even at sentencing. There's going to be some argument for culpability and that type of thing, but the same offense. So you're still stuck within that box. And the way that Arizona sentencing works is that they do, they start with the math. They say, how many prior convictions do you have? Okay, then you're in this category. And then what were you convicted of? Class 1, 2, 3, 4, 5, 6 felony. And that's your number of years that you're facing in prison. And the judge doesn't have an ability to go outside of it. And so, if accomplice liability brings you into a felony murder, judge can't help you as much as you would like.
Okay. So if you drove away the murderer from the party, are you very likely to be considered an accomplice?
Going to be fact intensive, right? I mean, as far as, but you certainly are at risk for that. It certainly could be charged that way. And you could be considered to be an accessory, and I believe, or they would call that, accomplice liability in Arizona is kind of general, whereas general criminal defense or criminal law would look at that as accomplice after the fact, which is generally looked at a little bit differently.
Yeah.
But certainly, yes, some that you could be liable for some level of that crime, whatever crime they committed.
Okay, so let's talk about this after the fact, because it's been a long time. So there's been a lot of things that have happened after the fact. One allegation is that parents took a child who had bloody knuckles, who was implicated in the murder, out of town to let him heal. And many, many comments on my videos are saying, well, that's obstruction of justice, or you're concealing evidence, you're destroying evidence. The parents should be charged.
Were the police looking for him and he was missing?
See, we don't have any arrest warrants. There are no arrest warrants.
There was no active case as far as I'm concerned. There was no, now you do have to be careful. Obstruction, where we see obstruction, not really obstruction, it's destruction of evidence. Is people saying, yeah, let me get rid of those bloody knuckles, right? They're going to find their way to the bottom of a lake somewhere. We're going to even scrub your social media.
Yeah.
Right? Stuff like that can be considered destruction of evidence. And that can be a felony by the parent, but generally it would be the person who did it. And again, how do you prove that the parent is the one who destroyed those things? And again, it would be just like any other criminal case where you have to prove who did it and how, and not necessarily how, I suppose. But you have to be able to prove the elements of the crime, which can be very difficult on a destruction of evidence thing because the evidence doesn't exist anymore.
Right. Okay, so this question was asked to Rachel Mitchell today at the press conference. Are you planning to charge the parents? And she left the door open. She said essentially no commenting on whether parents will be charged, but definitely left that possibility open. Have you ever seen that happen?
So I don't know. I haven't seen it as far as our clients being charged with that. I think it's, again, difficult to prove and pretty unusual. But I think there's certainly circumstances where if you can make the case, you would charge the case. And I think Rachel Mitchell is one of those prosecutors who, isn't going to charge a case if she thinks that it's an improper charge based on the evidence, regardless of what the public thinks, which can be hard, as an elected official. So I think that there's been a lot of talk about holding parents responsible, for instance, for mass shootings, things like that, where if somebody had the opportunity to talk to their child or do whatever. I think that we don't really have anything in the statute books like that. It would have to fall under our current statutes, which some type of accessory, or as we were talking about, somebody that actually helped. It can't be basically a failure to act or a failure to stop somebody from doing something. I think that maybe it would go back to what you talked about, where if there can be proof that the parent destroyed evidence or encouraged the child to lie or, obstructed justice in some way that was overt and active, again, in my opinion, my experience, very difficult to prove, but people aren't, expert criminals, especially people who, this is kind of a unique situation where you've got kind of these families that are not traditionally seen in this type of kind of circumstance, and maybe they make a bad decision. So I think that what they would have to prove is a criminal act by the parent.
Mm-hmm. Even if the parents knew that their kids were involved in going out and beating up random people, that wouldn't be a crime. Or could it be?
No. Yeah. I mean, I think that again, I always my brain always goes back to the whole proof part of that. How do you prove that the family or the parent knew that they were doing it? And how do you prove that they didn't do everything they could to stop that child from doing it as a juvenile? Now, I've actually seen cases, though, where, the parent, at least it was alleged, the parent actually encouraged the fight and said, hey, you don't let people disrespect you like that.
Yeah.
Right. You don't let people do that. And here's how we took care of it in my day. That could certainly be, some accomplice liability. But again, it's even that's kind of a stretch. I mean, it's kind of hard to prove that they could foresee that, their child would then take action on something like that. So I think you're getting into really unusual, kind of not novel, but not kind of what the county attorney is used to charging and what juries are great at kind of parsing through, because it's fairly complex. It'd be like a law school class to the jury, when you're in there trying to explain how it all works. And just like you heard, right, accomplice liability, somebody hears about it, it's kind of scary,
Right.
to think, oh, wow, this person didn't do anything, but they, are being charged. So you got to be careful as a county attorney when you're charging those cases.
Okay. There's also lots of talk about the children being on drugs, pretty hardcore drugs during this incident and probably other incidents. Would you ever get to a point where parents would be charged with contributing to the delinquency of a minor?
If you could prove, again, that they somehow condoned it or allowed it or provided it. There's actually a special statute that talks about providing drugs to a minor is very serious. I had a client charged with that, and the child actually died. And so it actually wasn't a parent, but it was an adult in the family that had provided it to him. So it is very serious, taken very seriously. But again, a lot of times it's kind of the proof issue. But if they've got the proof that these parents were somehow providing it, and you might even be able to stretch it, I don't know, and say, hey, if they knew that's where they were spending their money and they're giving them inordinate amounts of money and access to money, who knows? Maybe you can tie that back at some level. But again, I don't think that would then tie them to the act committed while on the drugs, just providing the drugs.
Okay. One family is accused of shepherding their child off to go live on a reservation in New Mexico. Is that allowed?
Sure.
There's no arrest warrant.
Right. Yeah, sure. There's nothing. Again, maybe, on the one side we're upset the parents aren't doing enough, and on the other side we're upset that they're trying to take them to a place where maybe they're going to learn some lessons, right? So I think that once, if there is an arrest warrant that comes out, that would be difficult to get them, but they could certainly do it. They just go through the U.S. Marshals, or there's different ways to effectuate a arrest warrant on reservations. It's not easy, but certainly can be done. And at that point too, if there's an attorney involved, they would generally coordinate the self-surrender, or do that in the best way that's safe for everybody, for law enforcement and for the defendant. So there is nothing wrong if there is no active case with release conditions saying you can't leave the state. You can leave the state. You can leave the country. You are still a free American citizen. Even when you've been charged, there's terms, there's release conditions on you once you've been charged. But those are subject to court change and things like that. So nothing wrong with what you just said there as far as sending them off to a reservation.
Got it. Okay. We have 2 arrests that happened today.
Involved the assault and aggravated assault back in November on a teenager here in our county. Now, this video became very public. A lot of you were very concerned about this video and what was going on with this case. It became very public in the media. This morning, we arrested 20-year-old Jacob Pennington of Gilbert for his involvement in that crime. Now, this is an ongoing investigation, so I can't give you a lot of answers. There could potentially be a few more arrests stemming from this crime, but I wanted to keep you up to speed on where we're at because of how high profile this video.
This was in Pinal County. This happened after Preston Lord's death. So
Yeah.
This video came out in November, close to a month after Preston had been killed, showing all of these people randomly beating up this other person. At this point, no arrest. The community is going crazy. Why aren't people getting arrested? Now, 20-year-old Jacob Pennington, who has been identified in quite a few of these videos and photos, has been arrested. What do you think he's looking at?
Well, that's always dangerous ground to kind of predict at this point. Part of it, your jumping off point is always, what are the charges, right? The sheriff kind of gave us a hint there that he believes it's aggravated assault, but keep in mind, he doesn't decide charges. The county attorney decides charges. So he gets to submit to the county attorney and say, I think this is an aggravated assault. Is it an aggravated assault? I don't know. I didn't see anything in that video that made me think it's an aggravated assault. Misdemeanor assaults can be really bad. But what it comes down to is there something assault plus, right? Assault plus a weapon, like you talked about before. Assault plus serious physical injury, like you talked about with, missing teeth, broken bones, disfigurement. Okay. So there has to be something serious to make it an aggravated assault. If we want to kind of pull up how sentencing works, in Arizona without boring people too much, but aggravated assault generally, it can be, multiple different levels. It can be a class 3, a class 4, sometimes a class 2. So class 2 is very serious. Class 3 is serious. Class 4 is, they're all serious. They're all felonies. But it, can even go down to a class 6. But really, class 4 is kind of the more common in class 3. So class 4, if it's non-dangerous, meaning it sounds silly, but non-dangerous aggravated assault, but meaning that they didn't allege that it was a deadly weapon or a dangerous instrument, they could go to prison for 1 to 3.75 years, 2.5 years presumptive, meaning that's where the judge starts as far as assuming that it's correct, if they get prison at all. If they have no prior convictions, he's a young guy. I don't know if he has any prior convictions. Juvenile wouldn't count. Then he's probation eligible, which means county attorney if it's not charged as dangerous, which changes all that, it makes it into prison mandatory, but the county attorney would have to give a plea offer that is probation, maybe probation plus jail, because the prosecutor knows if you go to trial and win, the judge could still give you probation.
Wow.
Yeah.
Okay. And then the other arrest that happened today stems from this post. So on December 22nd, Gilbert PD asked for assistance. So on December 22nd, Gilbert PD put out these photos and said to the public, we need your help identifying these, I don't know if they called them teens, individuals. We need your help identifying these individuals involved in an aggravated robbery that took place on August 18th. One of these people were identified, Christopher Fantastic, and he has now been arrested. But there were a lot of people involved. Now, in that particular case, the father of the victim has been very outspoken. The victim was beaten up pretty badly by a large group of people and then terrorized thereafter, so much so that dad sent his teenage son to live abroad with his mom to get away from the violence and intimidation that he was facing. People are angry at the police department. Do police departments ever get in trouble or ever have liability for failing to protect the public?
Sure. But it's unusual.
Yeah.
And police have a very difficult job where they have to walk this line between two competing interests, which is protecting the public and not violating people's rights.
Right.
They're really supposed to do both of those things. And so, I actually had a case in Gilbert where we had a client who was a minority who was being terrorized, racially, just the worst things that you can see, starting from his senior year in high school till 2 years afterwards. He was in ASU. He fought back and he got charged for a physical crime. And that was his family just up in arms, right, about how the police could just let this happen for 2 years. And it's tough because people are adept at using the criminal or the justice system in general of getting orders of protection, making it look like your son or your kid is the one kind of causing issues. But as far as the police have to work within evidence and within actual crimes. So there's things that are harassing and that are annoying and that are unfair and that are mean that are not criminal. Okay. So, but if you're talking about, people being harassed and beaten and, if there's any evidence of that, again, my experience in Gilbert is that they are more than happy to charge that case. Now, I'm not the parent there that is going through that with my child who wasn't taken care of. So obviously it's a case-by-case basis. I think suing the police or holding them accountable in some way can certainly happen. Case in point, we have Mesa, and I talked about them a little bit earlier, who's really had a string of accusations of just beating people. Okay. Criminal defendants for unjustified reasons, things like that. Multiple lawsuits. Actually, some of it stems from a really famous case where they shot a man who was on his hands and knees in a hotel hallway. I'm not sure if you remember that case. But the officer went to trial, actually. He was charged with murder.
Wow.
Went to trial and was acquitted. And I think there were reasons why he was acquitted. So it can become very difficult. I guess my point is that even though he was acquitted, the U.S. Department of Justice then started an investigation on Mesa PD, which is ongoing.
Wow.
As far as investigating them for civil rights violations. And that's generally, I've seen, really the most effective way to hold police agencies accountable is that it's the federal government doing it. Now, many times this is spurred on or started by people filing civil lawsuits against them, not something that we do. And I've heard it's a very difficult uphill battle to do. There's a lot of technical rules of getting it done right, but also, there has to be really strong evidence that they knew things and ignored those things or were negligent. And it happens. I mean, these police agencies are far from perfect. And so certainly I know that there's stuff out there, and I just feel for parents who are in that situation, who, basically have been victimized, or their child has been victimized, repeatedly, and feel just abandoned by the police. Anybody who's been a victim of a crime, it's, again, you get both sides of it, right? You got people charged with a crime who didn't do anything or who are being overcharged, and how oppressive that feels. Then you have the flip side of it, and you have victims. If you've ever been the victim of a crime, I've had a couple of times where I was the victim of a crime and felt like police did not care, did not matter. They were looking for any reason to not work on this case. And it's a terrible feeling. All right. And so it's a tough situation for everybody all the way around. But I think there certainly are avenues to look at if you want to consult with an attorney who does sue police agencies. There's a couple that are really specialized in that area. And then potentially they might be the ones that have connections at DOJ.
Oh, yes. I did have one other thing I wanted to ask you about. So one of the things Rachel Mitchell said today is when the Maricopa County Attorney's Office submits charges, they are required to present evidence that supports their case and evidence that contradicts their case. What does that mean?
So we talked about going to a grand jury, right? And that it's super secret in Arizona. Defense has no right to be there. Defense can't be there. Okay. So they are held to a standard where it's a strange situation where basically you got a police officer sitting in front of a bunch of grand jurors who do this on a repeated basis on different cases. And they're supposed to hear evidence and say, yeah, we think there's enough probable cause to move forward with charges. It's not that they're being found guilty. It's not a high standard like that. But you can imagine that in a situation that's so one-sided like that, there's a duty on the part of the prosecutor to say, look, if there's exonerating evidence, exculpatory evidence that shows that this person might not be guilty, it's up to them to do it, because, well, the honest truth is, if we find out later that they didn't, then we can get the indictment thrown out. So, and they would have to do it all over again. And there's ways for your defense attorney to kind of get involved in that as well. We provide a letter, it's called a Trebus letter, that really lays out all of that mitigating or exonerating exculpatory evidence that needs to be presented to that grand jury. And so that's a real advantage if you have somebody who can present that to the prosecutor, so that they don't get to just decide what they think is exculpatory to present. But that's what she means by that. Is it a fair process? No, grand jury processes are not fair.
It's just a first check the box, right?
There's an old saying, and I know you've heard it probably, you can indict a ham sandwich, right? Whatever the prosecutor decides needs to be charged 98% of the time, it's going to get charged by the grand jury.
Ryan, thank you so much for taking your time to come on the podcast. I really appreciate it. I think people will really appreciate having this information, especially from somebody local who understands all of the competing interests. There are so many competing interests. You can put yourself in the shoes of a parent whose child is a victim, or in the shoes of a parent whose child was caught up in doing bad things. You can understand how police officers have an impossible job. It's just really hard.
It is. It's tough. And thank you. It was a lot of fun. You made it easier for me than I thought it would be. So I appreciate it.
Thanks, Ryan. We'll have you back again, because I know we have a lot of other things to talk about. But thank you. Grand Canyon Law, right? For anybody who wants to contact Ryan, anybody who's got criminal defense questions, or you might be in that accessory bucket, contact Ryan over at Grand Canyon Law. Thank you.
Thank you so much.
Bye.
Bye.
Thanks so much for listening to the Modern Divorce Podcast. Remember, anything you've heard today or anything you read online is not the replacement for actual consultation with an attorney and does not create an attorney-client relationship. Even if you called in and we spoke to you, you were anonymous and we don't have your details and you have not become a client of Modern Law. However, we would love to speak with you, or you should seek out the advice of legal counsel or counseling or any other expert near you. And if you have an idea for a show topic or you need to speak with an attorney in Arizona, you can reach me at info@mymodernlaw.com.